Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing liability for social hosts. If you host a party at your home and someone gets intoxicated and drives home, are you liable for the injuries that are caused? The law on commercial hosts, like bars and restaurants, says there is some liability if a restaurant overserves a patron who then drives home and gets in an accident. But do hosts at private parties in their own home have the same liability? What do you need to know if you're hosting a party where alcohol is served? Is there a difference if the host serves the alcohol or if it's BYOB? And what if there are minors drinking? Here today to discuss these questions are three experts. Jessica Karijan is a partner at Castles Brock. Adam Wagman is a partner with Howie Sachs and Henry. And Dan Reisler is a lawyer with Aviva Canada. Thank you all so much for joining me today. Jessica, I'd like to start with you. I know that legal questions are always fact-specific, but as a general principle or general rule, is there liability for social hosts in Canada?
Thanks, Christine. So what I would tell you is that to date, no court in the country has found a social host to be liable for injuries sustained to a guest that has been consuming alcohol at their house. That said, our courts haven't shut the door to the possibility of a host, in fact, specific circumstances being found liable.
So, Dan, that's obviously different from commercial hosts. What type of liability is there for restaurants or bars if a customer gets drunk, drives home, and kills someone or is in an accident?
Yeah, Christine, it's very different. Bars and restaurants, places that commercially sell and serve alcohol, are held to a very high standard. The statutes in pretty much every province, I believe, give people a right to sue the bar. They don't have to prove that they have that right, as in the case of social hosts. The statute gives them a right to sue the bar if someone is injured or killed as a result of someone being overserved at a bar. As I said, the standards that bars are expected to meet are very high. Some people say impossibly high. They have to do things like monitor the amount people consume, look for and recognize signs of intoxication. You have to feed people. You have to give them coffee, water. You have to be prepared to call taxis, take away their keys, even call the police if necessary. In Ontario, up until recently, it wasn't even legal to advertise happy hour. Although the current government has changed that.
So, Adam, what's the policy rationale for treating social hosts and commercial hosts so differently?
Yeah, that's a great question. Thanks for having me on, Christine. It's a pleasure to be here with Jess and Dan. Service of alcohol, as Dan mentioned, in a commercial context is really highly regulated. And unlike at a house party, monitoring the customers is easy, and it's actually, a statutory legal obligation. You can't get up at a bar or restaurant and pour yourself a drink. Every drink is brought to you by an employee. The employee has special training that's actually required. In Ontario, we use a training program called Smart Serve. And it's mandatory for everyone serving alcohol. But, on the other hand, social hosts don't pour drinks for their guests. Necessarily, don't see how much their guests are consuming, and really don't have a statutory responsibility to do that. You don't need training to throw a house party, and I don't think any of us would want that to be the case. That there wouldn't be a lot of social hosts out there if that was a requirement. And then, of course, the overriding issue is money and profit. And, Dan mentioned impossibly high standards. Well, you know what? We're paying them to have those high standards. Bars and restaurants can benefit financially from over-serving people alcohol. They make profit. We know that. They're in the business to make money, as they should. But what happens is, of course, without legal liability, the cost of that damage is going to be borne either by the drunk person who leaves the bar and hits a pole, and people might not care necessarily about that person, but certainly the stranger crossing the street who's hit by the drunk driver. There's a great cost to doing that. Who's going to bear that cost? And in the commercial context, the policy decision, it should be the person, who's got a financial stake in serving that alcohol.
Now, we're running up against the commercial break, so I want to pose this question now, but we can address it in the next segment. The leading case is from 2006, a case called Childs and Desmoreaux. And I want to get into what happened in that case and whether that's still the governing law in Canada, whether it's been changed or adapted at all. I want to get into that in the next segment with you, Dan. We'll be right back. Welcome back to Canadian Justice, where we're discussing what liability a party host may have for guests who drive home drunk and cause accidents. Now, Dan, in the last segment, I asked you about the leading Supreme Court case, Child and Demoreaux. Can you tell our viewers what happened in that case, if it's still the governing law? What can you tell us about that?
Sure. Childs and Desormeaux was a really important case. The decision of the Supreme Court of Canada, as you said, from 2006, actually arose out of an incident that occurred in 1999. They sometimes say in legal circles that hard cases make bad law. This was the hard case that actually made good law. And what happened was Dwight Currier and Julie Zimmerman had a party in Ottawa. And they invited a bunch of friends, including a fellow by the name of Desmond Desormeaux. Mr. Desormeaux drank at the party. It was a BYOB party. The hosts weren't serving the people. And Dwight Desormeaux is said to have drunk about 12 beers over the course of 2.5 hours. He left around 1:30 in the morning. Mr. Currier went up to him and said, "Hi, are you okay?" And he said, "Yep," and got into his car and drove away. Unfortunately, he shortly after that ran head-on into a car and killed an occupant of that car and very seriously injured a teenager by the name of Zoe Childs, who was rendered paraplegic from the waist down. Now, Zoe sued, among others, of course, Desormeaux, of course, but she sued the owners of the home, the hosts of the party, Currier and Zimmerman, saying that they were responsible for letting Desormeaux drive away after having drunk quite a bit. And the Supreme Court of Canada said, no, these hosts are not liable. They referred to a number of, facts of the case, the fact that it was a BYOB party, and the trial judge was not able to find that the hosts knew that Desormeaux was drunk, although one wonders after 12 beers. But basically, they just discouraged the whole notion of social host liability. They said, generally speaking, there is no duty on social hosts to prevent this kind of an accident.
Now, Adam, in that case, the Supreme Court didn't totally exclude the possibility of social host liability. They left it open as a possibility that there could be something a host would do to enhance or create a greater risk. What might that look like? For example, would it apply if a host continued to serve a visibly drunk person if they knew that person was going to drive home?
Yeah, so what the court talks about is special circumstances. So just the serving of alcohol in and of itself isn't going to lead to liability. But where a host creates a risky situation, or if there's a paternalistic relationship or a right of control, the kind of key is that the host is implicated in the creation of the risk and they have control over the risk. And so, we're not just talking about the risk of driving drunk, and the court specifically actually mentioned the circumstance that you just described where where a host continues to overserve someone that they already know is drunk, and they've left that as an open question. But, we're also talking about situations where people are drunk and there's an inherently dangerous activity going on the property. You get someone drunk at your cottage, give them the keys to the ATV. You get someone drunk and have a pool party where people are jumping off, the roof of the house into a swimming pool. It's all fact driven, but the door is open.
Jessica, what do you think about this? Like, what would some factors be to potentially open the door? For example, what if there were minors drinking at a party? Would that create liability?
Yeah, so Christine, we've had two pretty recent cases that addressed the situations of minors drinking at parties. One was a case called Wardak in Frome, and the other case recently came out of the BC courts. Dan is smiling because we did Wardak and Frome, but out of the BC courts is this new case, McCormick versus Planback. And what we had there is the Pearson family whose daughter hosted a party. And the Pearsons, as the parents, did a lot to ensure that the party would be very well controlled. So they're sort of a good example, if you will, as to what can you do to minimize liability and where will the court say no. Because in this case, you had a fairly well-controlled party where it was BYOB, no one was to drive, there was no car keys. But what you did have was a 17-year-old and an 18-year-old who left the party and unfortunately stole a nearby car where the keys had been left in the car. It was a small community where people knew one another.
Jess, this is so important, but we got to go to break. I want you to finish when we're back. Welcome back to Canadian Justice. Now, Jessica, I wanted to follow up with you on what you were saying in the last segment about a case in British Columbia called McCormick involving minors drinking at a party. Can you elaborate on what happened in that case?
Yeah, so Christine, we had the Pearson household, the Pearson's daughter hosted a party and the Pearsons, the parents were around, but there were minors there drinking alcohol. The parents were monitoring. It was BYOB. They were ensuring that nobody was going to drink and drive. Unfortunately, two people, a 17 and 18-year-old left that party and they stole a nearby car where the keys had been left in the car, which happened to be for sale at the time. And shortly after taking off in the car, they were involved in an accident, and one of them died, and the other was severely injured. So the Pearsons were sued, and effectively the BC court said, you know what, the BC court. So in that case, the judge took sort of judicial notice or understood that Salt Spring Island, where the accident occurred, was a small, close-knit community where it was common for minors to drink and smoke marijuana, etc. And said, you know, given the circumstances, the parents here did everything right and did not find liability on the parents. So that case is a good example for what you can do to not be found liable as a parent when you have minors in your house drinking alcohol.
I'm so fascinated by this question of what circumstances could create liability. So Adam, for example, I live in Toronto, which has many public transportation options available. Is there a different ability to create liability between people who live in cities where public transportation, Uber and cabs are all readily available versus someone who hosts a party in a more remote or rural community?
Yeah, it's a great question. And, I hate to give kind of the lawyer answer of it depends, but, it all does depend on the facts. If you, as a host, ask a visibly drunk person, how are you getting home? And their answer is Uber in the city of Toronto, that's a totally reasonable answer. And frankly, if the person then leaves your house, gets in their car and drives, I can't imagine that a court would find that host liable. If you live in a rural community where that there is no Uber available and the same conversation ensues, the host might have to think twice about how that person is getting home and whether they have a responsibility to do something about it or not, again, depends on the circumstances. In a rural setting, that people are either driving or getting a lift from someone. And do you need to ask how they're getting home? Morally, I think you should. And just describe circumstances where you can defend yourself as a host, right? Legally, it really does depend, on some of those circumstances that we've described earlier. You don't need to give them a lie detector test, that's for sure.
Dan, I'm still interested in the issue of minors. I mean, we're in grad season here in Ontario, a lot of grad parties taking place. And I wonder if there's a difference between a party being hosted when the parents aren't home versus when they are home. Is there a difference in the ability to attract liability if your kids throw a party because you went away and one of the kids drinks and drives home drunk? Is that kind of a no liability possible situation, or could it still happen? Well, I'm asking, should parents just turn a blind eye maybe?
Well, I'll tell you what we did. We hosted our daughter's graduation party from high school, and they all, about 100 of them arrived by bus, by coach. And we hired a security company. We had 2 security guards, and my wife and I went out for dinner for the night. And so, luckily, nothing untoward happened that I know of. But we removed all the breakables and valuables and covered all the furniture, and everything was fine. We were not home, so that's one way to do it, I suppose. I don't believe being absent necessarily attracts liability. It just, it depends on how you handle the situation, and to some extent, you have to know the crowd that you've invited. But if you are home, and that if you are home, you actually, I think, have to pay attention to what's going on, because I think you have a bigger problem if you're home and bad stuff is going on, like really, excessive drinking and or drug use is going on under your nose, and you're ignoring it.
Right.
So
it's just interesting to see what different incentives the law creates for social hosts. We've got to go to commercial break, but when we come back, we'll continue this discussion. Welcome back to Canadian Justice, where we're discussing social host liability. Now, Adam, if there is an obligation on guests to say, I won't serve you anymore, you're driving, that's a conversation that makes a lot of people uncomfortable. Do you have any advice about how to have that conversation with your guests?
Yeah, so one of the things that is really concerning about this conversation, we're talking about the law, and we haven't talked about your moral obligation. When I have guests over, I want to make sure that we have a great time. I want people to want to come back to my house, and I want people to be alive to come back to my house. And I would absolutely hate, I couldn't live with myself if I knew that I could have done something to stop people. And frankly, at least from a moral perspective, it's your house. And a lot of the time it's your booze. And if you're uncomfortable making sure that your guests are, or doing your best to make sure that people are safe when they're at your house or when they leave your house, maybe you ought to think twice about having people over. I don't think that people should feel uncomfortable at all about saying to someone, hey, do me a favor, driving drunk isn't going to happen here. We're going to call you a cab, and we're going to find we're going to call the cops, or we're going to call a cab. It's your choice.
Now, Dan, a kind of similar question to you. Drinking and driving is terrible. It has caused so much hardship for so many families, and we don't want to encourage anyone to be doing that. So how do you have those conversations with your guests? Do you have any advice on that?
Well, I think you have to be, first of all, you have to try to prevent the problem. You got to try to make sure nobody gets, intoxicated to the point that they're going to make a bad decision. But if that happens, and it does happen, then, you have to be direct with people, and likely they'll thank you later. And just tell them you can't drive. And if you're able to, take their keys, call them a taxi, and be direct and be, somewhat forceful if you have to.
Jess, I want to ask you really briefly, we've been talking about alcohol use, but how might these kind of legal principles apply for example, drug use or cannabis use, if someone's a guest at your home is using cannabis and driving, which is also a criminal offense?
So, Christine, I would treat a guest who's smoking cannabis at my house the exact same way I would treat a guest who's drinking alcohol, albeit if somebody, for example, smokes a joint at my house, that's the point where they're not driving home or going to do anything dangerous. Whereas if somebody's had a beer or two or a glass of wine, I'm probably not going to question their ability to drive.
Jess, I want to close with you with the last question, which is, as we've said, the courts have left the door open. For now, the general rule is that there isn't social host liability, but that there could be if the right facts present themselves. So do you think that it's, maybe a matter of time before courts do find someone liable eventually for allowing a guest to leave their home impaired and driving, causing an accident?
I absolutely think that could be the case. I think, a case will likely present itself that is frankly the perfect storm. maybe it's forcing your guests to play beer pong and then take their car keys. There's got to be a lot of negligent behavior on the part of the host. But to that end, as a homeowner or a renter, for example, that's why it's really important to ensure that you have a really great insurance policy. Because at the end of the day, if you do find yourself in a position as somebody who's getting sued for that reason, then your insurance policy is likely going to respond for you and take that out of your hands.
And of course, as always, preventing something like this is always the most important approach. Adam Wagman, Dan Reisler, Jess Karijan, I want to thank you all so much for coming on to talk about this. Jess and Dan, I know you worked on one of the leading cases on this topic in Ontario. So your expertise, and Dan has worked on countless cases related to this as well. Thank you so much for providing your insight and expertise today. It's been so informative.
Thank you,
Thanks for having us.
Thank you.
We've heard today about the liability you may have if you host a party and a guest drives home drunk. But remember, even if there are maybe limited situations where social hosts have been found liable by the courts, the right thing to do is to talk to your guests. Offer to call them a ride or to stay over or start serving water or coffee. Drunk driving kills people and ruins lives. And even if social hosts are not often found guilty in the courts, how would you feel if one of your guests caused an accident? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.